tonight, not tonight, this afternoon, we're going to have a board hour demonstration, and let me introduce the people that are going to be doing it. In this corner is Charlie Grant. Charlie was an assistant county attorney, and he quickly developed a reputation as being a very good trial lawyer. And he graduated from St. Mary's in 1990, and then went to Dallas, worked for big law firms for about 4 years, and decided it was time to do something different. And then he went to work for the county attorney's office. And Charlie, do they still have the chair system? Are you considered the number 2 chair now?
Second chair, yes.
Second chair. And anyway, he's done a lot of DWI jury trials, and he's been very effective, so he's going to do the demonstration for the state. Now, Leon Grizzard, sitting over here, I haven't asked Leon his background, but Leon and I used to office together, and when I first became aware of Leon, I knew him primarily as a musician, and I think he took his lawyering very seriously, but he was really rather be out playing music, but that turned out to be false. It's still true. Well, it's true that he'd rather be playing music, but he's an excellent trial lawyer. While I was in the office, during the 5 years I was there, he tried 2 capital murder cases, and in one of them he got an outright acquittal, and in the other one he managed to get a life sentence for a guy who had killed a DPS trooper, and the state was hot and heavy to get the death penalty in that one. So I've been very impressed with the work that I've seen Leon do. But anyway, gentlemen, take your places and let's go. I must say, I also, in one case, I was in a veneer, and I actually I was part of the board. I mean, I was actually a real veneer person, and Leon was a lawyer, so I've seen him in action. Okay, Mr. Grant, you may proceed.
Oh, thank you, Your Honor. Good afternoon. As the judge said, my name is Charlie Grant. I'm an assistant county attorney in Travis County. And also we are here today because Mr. Alvarez has been accused of driving while intoxicated. This part of this proceeding is called Voir. It gives us and the defendant and his lawyer an opportunity to talk and discuss with the jury. It's actually the only time we can actually talk back and forth to one another in the entire trial. We want to try to find out things about y'all and try to pick 6 jurors who can be fair and impartial to the defendant and to the people of Travis County. An old friend of mine once said, the hardest thing to change is a made-up mind. So we're going to be trying to find out something about just your experiences and your feelings on things to see if you are to find the 6 best people to sit on this jury. After we'll talk, if I don't want to get personal. If anything, if you'd rather not share something with 17 or 18 of your newest friends, raise your hand and we'll go out in front of Judge Shub and discuss it up there. Does anybody know me? I look around, I don't see anybody that I recognize. How about the defendant, Mr. Alvarez?
Yeah.
And Mr. Grizzard, his lawyer?
Okay.
What about the judge? Nobody? This, like I said, is a DWI case. Mr. Daly?
Yes, sir.
Have you ever seen someone you thought was intoxicated?
Yes, I have.
What made you believe that person was intoxicated?
By the way he was acting.
How was he acting?
He was staggering around and being very loud and belligerent and basically making a fool of himself.
Did you know, was that person with you, or did you see him?
No, he was not with me.
Did you know him previously?
No.
Did you have to know him previously to reach your conclusion? I guess not that he was intoxicated.
No, I did not know him, and I could just tell by the way he was acting that he was just very heavily intoxicated.
Thank you. Mr. Berger,
Yes, sir.
have you seen someone you thought was intoxicated?
Well, yeah, I've seen some people that I thought were intoxicated, and I've seen some people that But I thought weren't intoxicated, it turned out to be a little bit more intoxicated than they had previously thought.
So you've seen people that you, when you first saw them, you didn't think they were intoxicated, but you later found they were?
Yeah.
How did you find out later that person was?
Let's just say I've known a few people that had to take a breathalyzer test.
Oh, you do? How'd you come across that?
Well, I'd kind of like to talk about that maybe in front of the judge.
Okay. We'll do that. Mr. Hopkinson, do we want to do that just standing up?
You just have to stand up.
Okay. And pretend it's later? All right.
You want me to stand up now?
Sure, go ahead. Earlier, Mr. Bird, he said that you'd rather talk to the judge about some things about the intoxicated test.
I was arrested for DWI a while back, and I didn't think I was that drunk. I didn't think I had that much to drink. It turns out I ended up with 109, a breath test. I escaped death and dodged a bullet on that one.
How do you escape that?
Well, I mean, they didn't get convicted or anything.
Did you have trial?
No. It was dismissed.
Did anything in that experience that would affect your... How did that affect you? Do you still drink alcohol?
I try to watch myself when I go driving. I try not to drink too much, but it really impressed upon me how little alcohol can register big on a breathalyzer test.
Do you think that the test was accurate?
I've heard a few things about it from my attorney at the time. Told me that it wasn't that reliable.
Do you believe that?
Well, it seemed to make sense. I mean,
So if I presented evidence, including evidence of intoxication through intoxicalizer, would you be able to follow that?
well, I'm not sure. You know, if you only presented evidence of the intoxicalizer, then I might be a little bit skeptical. But if you had more than that, then I might be able to listen to that.
Fair enough. I don't have any questions, John. Thank you, Mr. Burke. Mr. Burleson, how about you? Have you seen someone you thought was intoxicated?
Sure.
What did that person act like or look like to you?
Oh, they were staggering, and bloodshot eyes, and, cussing and speaking loudly.
Have you known people who were intoxicated?
Oh, sure.
When you cuss and speak loudly, do they not normally cuss or speak loudly?
Yeah, I think they're just a little less inhibited.
Okay. And what about their balance?
Oh, they don't seem to manifest too many motor skills.
Okay.
Seem to be bouncing all over.
How'd you know if someone, I believe, Mr. Daly?
Yes.
You said, how'd you know that person was intoxicated across the room? Did you see him drinking, or did you just...
It was the way he was acting, and he was being very loud with a drink more so than a normal person.
Okay, well, alcohol versus a drug or something. Like if I were acting the same way, and I came up to you right now, and I said, come here and shake your hand, I breathe all over you, how would you know that I was... Would you get an idea how that I was had drunk alcohol instead of taking a drug?
Well, if you had alcohol in your breath, then I would assume that you were drunk because of alcohol.
Okay. Miss Ford, have you seen someone you thought was intoxicated?
Oh, yes.
Do you have anything to add to your other jurors' descriptions?
No, pretty much have observed the same thing, kind of maybe glassy-eyed, slurred speech.
Okay. What kind of mental faculties, Ms. Ford, do you think it takes to safely operate a car?
Well, I mean, the number of accidents we have, it's obviously more than the average person thinks is needed. But I think you need full control of your mental faculties to...
Well, which faculties? Like what, I think Mr. Burleson talked about inhibitions or I assume of judgment, you not using judgment. Do you think proper judgment is necessary to safely drive a car?
Sure. You have to judge distances, and you have to judge all kinds of things, so, yeah.
What do you know of anything, what alcohol does to reactions? Does it speed them up or does it slow them down?
Oh, I believe it slows them down.
So do you think it might slow somebody's reaction time? Have you seen someone who you thought was intoxicated just act a little slower or a little less alert than someone who wasn't, or than that person was when he wasn't drinking? If you
Well, I
haven't
would,
confused you.
well, sometimes people that are drunk are faster, but that doesn't mean they're better.
Right.
So they might just be hyper,
Thank you.
instead of just slow.
Mr. Berg, what about physical faculties? What kind of physical faculties do you think are needed to safely operate a motor vehicle?
Well, I don't know, I just think that you have to have, I would think, a careful mind, I guess. You don't want to, you want to make sure that you're not, that you're paying attention, that you're not, your mind isn't wandering, you're focused on what you're doing. Something like that. I don't think that you need to have full capacity. I mean, I've taken antihistamines before, cold medicine or something like that, where I've been able to drive safely, and I don't think that you need, but I do think that you need kind of a clear mind.
Thank you. Mr. Burleson, what about you? Physical faculties necessary to safely drive a car.
Oh, you need to be able to see, you need to be able to use your hands and feet, and that's about it.
And what about, what if someone who's, has a problem balancing, standing up? Do you think that person would, because he's sitting down in a car, do you think that problem, what the evidence of that balance problem would affect the person's ability to drive a car?
I wouldn't think it had too much impact, to be honest with you.
So if a person's falling down drunk, you think he could drive?
I don't think this balancing has anything to do with it, but I wouldn't trust that guy behind the wheel of the car.
Okay. Do you think, you wouldn't, I got you. Why not?
Because he probably can't control some other stuff,
Like what?
like his delayed reactions and, the way he reacts with lights and stop signs and things like that. But I wouldn't, just because he can't walk the tightrope, I don't think there's not much relationship between the way he drives.
Okay, thank you. I would usually have a chart with the law. I'm going to show you all the law. Basically, the law says a person commits an offense if he drives or operates, I believe now it's just operates, a motor vehicle in a public place while intoxicated. The issue in these trials is usually intoxication, which is defined as not having the normal use of mental faculties or physical faculties, or has a alcohol concentration of 0.10 or greater. There are therefore three ways to prove it under the law. One, if a person has lost the normal use of his mental faculties, law says he's intoxicated. Or physical faculties, law says he's intoxicated. Or if he has an alcohol concentration of 0.10 or greater, the law deems that person to be intoxicated. Anybody have any questions about that? Ms. Ford, do you think that's a good law? First of all, the law is against DWI.
Oh, sure.
Okay, do you think they're necessary?
Well, yeah, if you don't want to get hit by drunk people.
Okay. Do you think this law is a good way to, the definition of intoxication, what do you think about that?
Well, I don't know, I guess I would just trust the lawmakers to decide what intoxicated meant, from a medical standpoint. I'm not a doctor, but I guess they have, I've seen them on TV, but I just feel like if the lawmakers said that that's intoxicated, then that's what it is.
All right, what about, though, if you were a juror, applying this definition that the legislature has set, you're right there in their infinite wisdom, applying that definition to see if do you think that's a fair definition of whether someone is intoxicated, loss of mental faculties or physical faculties, or a 0.10 due to alcohol? Do you think that's...
Yes.
You think that's a fair... Can you think of a better way they could have done it?
maybe a blood test,
Well, what would that blood test measure?
the alcohol level.
This third prong?
Right.
So there's certain ways perhaps to reach that level. There are instruments to measure that 0.10, but like in Texas, a person generally who's arrested for DWI can't hold them down and draw blood from them. Or Mr. Bird was talking about the breathalyzer, can be forced to provide it, to blow into the tube. So we have the loss of mental or physical faculties as well as the third prong. How about those? Do you think you could work with that? Do you think that's a fair way to tell if someone's intoxicated?
Well, it's kind of vague, I guess.
What, do you have a question about it?
Well, I mean, how are you going to judge loss of mental and physical faculties?
All right, well, what would you like to see? What kind of evidence would you like to see of loss of normal mental or physical faculties?
I'd like to see a blood test showing that they had a high alcohol level.
Okay, you'd require a blood test?
No, I wouldn't require it, you were just asking me.
All right. If you didn't have that, what would you like to see?
If I didn't have that, what would I like to see? I'd like to see a videotape showing me that he was dropped down drunk.
Or a video at the scene?
Sure.
Or if there wasn't a video at the scene?
Well, you're just asking me what I'd like.
No, I'm not.
Yeah, I'm just telling you.
Okay, well.
I'd like to have been there to see for myself, but I wasn't there, so.
If you weren't there, I don't mean to pick on you, but you're raising some good points. If you weren't there, could you say Mr. Bartleson was there? And you asked him, well, what happened yesterday? He goes, man, I saw a wreck out there. The blue car ran into the red car, and you didn't see it. And you didn't have any reason to doubt Mr. Bartleson, or you found him to be credible. Could you convict somebody of running that stop sign that the red car ran based on his testimony?
If I found him to be credible, sure.
Okay.
If I made that judgment that he was credible and I believed him, and there wasn't somebody else that I thought was more credible saying something to the contrary, sure.
Very good. Fair enough. Mr. Bartleson, how about you? Back to the law. Do you have any questions about the law of intoxication? How it's defined?
It just sounded a little vague, but I guess I can kind of understand that.
Well, what do you mean vague?
Well, I mean, the whole normal function thing. I mean, I've just seen a lot of people who've been pretty damn drunk, but I'd still let them drive, and other people who, but I'm, pledge brothers and stuff, but other people who, I just wouldn't even trust them, even sober. So I understand that you can't always have a numerical value assigned to something, so, it makes sense.
Okay. Speaking of, I will say pledge brothers, have you known some that could drink 12 beers and act pretty much the way they did before?
Yeah, juveniles help, yeah.
Okay.
Same sober as they were.
All right, what about someone who could have a couple of beers and act silly and not act themselves and be maybe falling or laughing or saying things they wouldn't say?
Sure.
Under that definition, that person who has 2 beers, or any person that is saying things he normally wouldn't and acting in loss of judgment, would you say that person lost mental faculties?
Probably so.
So that person who had 2 beers
is getting penalized, more heavily than that person who was stone cold drunk, under the law.
Why is he getting penalized more? If he's
because it just seems kind of unfair that, he only had a couple beers and this other guy's just, knocker, he's got a lot more beer.
So he's got a little fun and...
Yeah. Yeah.
He can't have as much fun as this brother.
Kind of fair to me.
So what about a person who weighs 50 pounds versus a person who weighs 200 pounds? Is that unfair?
It still sounds a little unfair, but I mean, we'll have to accept that.
Can you accept that?
I can accept that.
Could you find someone, if you found someone had lost mental or physical faculties after 2 beers, and that person couldn't balance and had lost and was cussing and normally wouldn't, would you say that person is intoxicated?
I would say that person's intoxicated. It's not fair, but I'd still say it's intoxicated.
Okay, that person just probably ought to watch what he drinks, I guess, when he drives. All right, thank you. Ms. Ford, you said in your cards here, you mentioned or you checked off that you've been a witness in a criminal case. I believe, is that correct? Yes. Can you tell me about that?
It was an assault case.
Were you Did you witness the assault? And what happened?
Well,
Who did you testify for?
for the state,
Okay.
for the complainant.
And was it a misdemeanor assault or felony assault?
That was misdemeanor.
All right. Can you tell me, was the defendant found guilty? Do you remember?
Yes, he was.
Was it someone, and I would ask this later, was it related, was it a family deal where you knew everybody?
Not in my family.
Did you know the victim and the defendant?
Yes,
Were they related?
yes.
Were you related to either of them?
No.
Okay. Mr. Daly, what is, may I ask you, your Presidio Enterprises? That is Mr. Burdick's fourth on here, I'm sorry. Can you tell me what Presidio Enterprises is?
I believe they're an information services company.
Okay. And back to the definition of intoxication, we all talked about people that we've seen that were drunk. A lot of people said stumbling down. Does everybody see or can that this definition does not require to be stumbling? There's, like if this were sober as church mouse right here, and this were comatose drunk, and stumbling drunk is around here, can, Mr. Bird, what do you think about, where would the definition of intoxication fall in there?
Well, if I understand correctly, you have loss of mental faculty, or you have loss of physical, or you have just the breath test. So it could conceivably be, as far as loss of physical capacity, could be all the way up there, couldn't it?
So this could be if like...
As long as there was still a drunk, there was like, somehow you could show loss of mental.
Right, one of Mr. Burris' friends who had 2 beers and he's silly or stumbling around, he might be down here, but he's still intoxicated and has lost.
Shows up on his breath test.
All right, Mr. Daly, what about the third prong, the .10 on the intoxilizer? Has anybody not heard of the intoxilizer? They used to call it the breathalyzer. Everybody heard that? What if someone was .08, which is below 0.10, but yet they couldn't balance very well due to alcohol?
Shouldn't be on the road.
Okay, is that person under this law, under this definition, that person still intoxicated?
I would say so.
Even though he's not over 1.0?
No, I think that he would be drunk and he doesn't have any business on the road driving.
Okay, why not?
Because he could hurt somebody because he doesn't have the normal use of his faculties.
All right, thank you.
Mr. Grant, 4 more minutes.
4 more? Thank you, Judge. Anybody ever seen anybody do what they call field sobriety tests, the touching the nose or the following the pin? All right, Mr. Burleson, I'll start with you. Have you ever done it?
No, I don't.
Have you seen them done?
Yes.
What, do you remember, were you just driving by, were they buddies of yours, or?
There were a couple of buddies.
That's some good friends. Which tests did they do remember?
They did that ABC job and the touchy the nose and the leg and the ear thing.
Okay. Do you think those are, do you think it's first of all fair for a police officer to ask someone he or she pulls over, maybe smells alcohol and breath?
I don't know, I guess it makes sense, but it's kind of silly, the things that they have to do. I mean, how'd you like to have somebody say, can you do your ABCs? And it just kind of sounds silly, but I guess if that's the only way they can do it,
Well, I mean, would you do it if someone asked you to say your ABCs?
Well, I'd ask them why first, but yeah, I'd do it.
Have you ever been, had been drinking or friends drinking?
I don't drink personally.
Okay, were they getting mush mouth,
Yeah.
Okay.
And so, I mean, I guess it's a way to see, but I mean, it's kind of silly, and it made sense, and certainly my friends kind of fell over, and some of them kind of stumbled on D and F and all that.
Okay, so that person intoxicated?
Yeah, they seen it.
So they couldn't pass the ABCs, and,
They had trouble with it.
okay.
Yeah.
What other, the one, that leg in the area you said? What is that testing?
Balance.
Do you think it's a good way to test balance?
I guess other than just standing up, sure.
Do you think most of your buddies could probably hold one leg in the air for 20, 30 seconds when they weren't drinking?
Yeah. Sure.
Could they do it when they were drinking?
Some could, I'm sure some could.
The more experienced drinkers
Yeah.
can hold their,
Hold the liquor and their balance.
Okay. Thank you. Ms. Ford, do you think it's fair for a police officer to ask someone who pulls over if he suspects they've been drinking to come out and do some little simple agility test to show that they're okay to drive?
I guess it would depend on why he thought they were drinking
Okay, say he smelled odor of alcohol on him.
before he stopped them.
No, after, like he stops him for weaving, or running a stop sign, or some traffic infraction, maybe speeding, approaches the car, window rolls down, odor of alcohol.
Yeah, I probably that'd be fine.
Okay. Anybody here think it's not fair? Mr. Yellow?
Beg your pardon? Well, I have a little problem with them, with the type of test they give.
What type of test?
Like a one-leg stand and things like that.
Why, what's your problem with it?
Well, because I've tried to do it.
Actually, I haven't had a drink, so well, I think it's a difficult test when you're sober.
I've opened it up now. The back row is raising their hand.
Well, I just want to say, those are typical tests for cerebellar function and neurologic science. I mean, they've adapted that from medicine. That's not just something they thought of.
But they have
Mr. Red, do you have some training?
Yes.
Do you have some, Dr. Red, Dr. Red. Dr. Red. How does alcohol affect the brain? Mrs. Red, or Ms. Red, I'm sorry, I'll be...
Oh, I just had a question.
Okay.
I wanted to ask Mr. Red, Dr. Red, if people that fail those for neurological reasons aren't allowed to drive.
Well, I advise them not to if they have cerebellar dysfunction.
Dr. Red,
Can I ask Dr. Red a question?
how does alcohol affect motor function?
It affects it primarily in the cerebellum, and where it coordinates all the activities. And as you've very elegantly pointed out, you can have difficulty with body or truncal coordination, difficulty with oral coordination with your tongue and your palate and your lips and your diaphragm. And then also, there can be a third form of coordination difficulty, which is utilization of arms and legs. And these are three ways in which alcohol affects the motor function.
Thank you, sir. My time is up.
Good afternoon, members of the jury panel. Once again, my name is Leon Grizzard. I'm a lawyer here practicing in Austin, Texas. Mr. Victor Alvarez is my client. Everyone has said that you don't know him. He is a Nicaraguan exchange student, attends the University of Texas. We anticipate we're going to have one other witness we're probably going to call is Pablo Floriendo, who is his roommate. Does anybody know him or recognize that name in any way? Okay. I'm not going to go over the same ground too much that Mr. Grant has covered. He's done a good job, and I think we have some people's ideas about alcohol use, but I need to address a couple of things. I don't, again, want to revisit the same stuff as he has exactly. I guess before I go further, Ms. Ford, I'm going to have to ask you, you had said that you had witnessed some field sobriety tests in the past? Is that correct, ma'am?
Yes, I have.
And may I ask you, please, ma'am, the circumstances of that?
Well, we were in New Braunfels, and a police officer pulled my husband over because he had gotten weaved over the line, and we don't drink at all either, either one of us, and had kids in the car and everything. And he had him, he had him in the back doing the field sobriety tests, and kids and I were just in the front laughing about it. And then the officer, I don't know if he failed him or not, because the officer came up to the car and said, "Ma'am, is he all right?" And I said, "No, sir, but it's not alcohol." And he asked to look in the cooler, and I just told him that all we had in the cooler was soda water.
Okay. Well, why do you think he was having him perform those field tests in the first place?
Because he went over the line, and he thought that he was weaving, but he wasn't. He was just talking.
He didn't have any odor of alcohol on his
No.
breath or anything
Didn't drink
like that?
No.
Do you think the officer, were you somewhat surprised since he didn't have any odor of alcohol that the officer was having him perform those field sobriety tests?
It was amusing.
Okay. Did you feel like the officer was behaving properly by doing that, or did you feel like he...
Well, I thought that it was attributable to the fact that it was on River Road, New Braunfels, and that there's a lot of drunk people there, and so they're probably like high or something.
Okay.
I thought he was being hyper alert, but I thought that in the area, that could be understandable.
Okay. So you sound as though you don't hold any resentment against
No,
this
it's just
officer
fun.
for doing it. It turns out being an amusing thing.
It was fun.
Okay. We have two people I know on the panel here on the front row who said they don't consume alcohol at all. Is there anyone else on the panel who does not ever consume alcohol? Okay. Guess I need to ask you, Mr. Burleson, you said that you don't consume alcohol. Has that been all your life, or just something you have come to in the recent past, or?
Been fairly all my life, but not all my life, probably about the last 6 or 7 years.
Okay. I guess, if just swore I would ask you the same thing. Have you not ever had a drink of alcohol, or?
Well, I guess maybe I spoke too strongly when I said don't drink at all. I mean, have a drink socially on occasion, but, and have nothing against it. Just don't drink on a regular basis, and certainly wouldn't drink and drive, but, if I were to go to a restaurant and have a margarita, that would be all right.
Okay.
But when
I'm sorry, I didn't mean to interrupt.
Okay.
I don't drink either. I've never, I don't touch this stuff.
Okay.
Never in my life.
Never in your life?
No,
Okay.
sir.
Can you articulate the reason why you?
Well, that's just the way I was brought up.
Okay.
I'm a
Okay.
very religious man, and I belong to the Church of Christ, and my father didn't drink, and his father didn't drink, and I certainly don't drink, and that's about it.
Okay. How do you feel about people who do? And
I think they're bad, I don't think.
I appreciate your humor. And so I guess the question would be, and this is really, I guess I would have this for you three as well. There are sometimes people who don't consume alcohol, and I don't know, I'm groping for words, don't feel, as you said, think that people who do are showing, if I could put some words in your mouth, some weakness or something like that. And I suppose the question I would have for you, I think there's going to be some evidence. I think that unlike this unfortunate situation that Ms. Ford's husband went through, I think there's going to be some evidence that that my client at least had some alcohol on the evening in question. So the question is, are you going to kind of automatically conclude that he was intoxicated under the law because of the fact that he simply had consumed some alcohol on that occasion?
But to be honest with you, I would probably hold it against him.
Now, the law is that a person is allowed to have consumed some alcohol and to operate a motor vehicle so long as they are not intoxicated. And I guess the question is, are your feelings about alcohol so strong? And again, everybody wants to say, I can be fair, I can follow the law, but we have all these things that we feel strongly about. Are you going to be able to give him a fair shake, or do you just even right now have some feeling that he is guilty of the offense?
Well, I understand from what was explained to us about the law that you can drink and have something to drink and not be too drunk to drive is my understanding from what the other attorney told me. But I may, being that I've never drank myself, I may have a little bit of difficulty with sympathizing with the defendant, and all I can say is there's a possibility that I may hold it against him.
Okay. We may ask you at the end of the voir dire to approach the bench, and perhaps we'll explore that a little bit more with the judge. Thank you for your honesty on that. I guess with you other two who don't ever or rarely consume alcohol, that same type of question, do you think that either of you would, I hate to say, because nobody's going to say I would automatically convict somebody of driving while intoxicated if I found they had had some alcohol, but how do you feel? I think you understand what I'm trying to get to inartfully. How do you feel about
If I pass judgment on people like that, I wouldn't have any friends.
Okay.
So, it suits them and all, and it is a sin, but I don't believe in convicting them personally.
Okay. Now, when you say that it is a sin, are you saying that consuming alcohol is a sin, or the drinking and driving is a sin, or both?
Drinking alcohol to excess.
Okay. But in moderation, that's not anything that you feel so strongly about. You're automatically going to convict poor Mr. Alvarez because he had a beer at the party.
Right.
Okay. And ma'am, how about you?
Moderation is the key.
Okay. Okay. Since I guess we've asked everyone else, how do you feel about this topic in general, sir?
I certainly don't think it's a sin to drink, so I would have to agree with Ms. Ford.
Now, we all, as Mr. Grant explained, the law in Texas is that you can have consumed some alcohol and operate a motor vehicle. You simply cannot operate a motor vehicle while intoxicated. And what intoxication is, as you've seen the definition up here, it includes either losing your mental faculties, or rather being impaired in your mental or physical faculties as a result of alcohol, the normal use of your mental or physical faculties, or is having an alcohol concentration above 0.10. And we're going to talk about each of those just really a little bit. I think we had somebody back there in the back who said that he can't do those field sobriety tests even when he hasn't had anything to drink at all. And I think that raises a valid point that, they're just throughout the trial, is everybody going to automatically assume that anything that an officer testifies to that may be a symptom of intoxication in some people always is a symptom of intoxication. And I don't need to show of hands on this, but I think everyone understands the point. The law says if you have lost the normal use of your mental or physical faculties, and obviously that normal use has to be for the person in question. It is not just because 90% of the people can stand on one leg and hold the other one out, does not mean if you're one of those people who can't, we should conclude that you're intoxicated. And along those same lines, we have this alcohol concentration. The Texas law is that you're considered to be intoxicated if you have an alcohol concentration of 0.010% or greater. And this is, as you can see from the chart, measured in a variety of ways, depending on if you're measuring someone's or looking at somebody's urine, breath, or blood. I think there's going to be some testimony in this case regarding what is called the intoxilizer, as Mr. Grant said. And this is not the time for us to go into everything about the intoxilizer, but is there anybody who, if a intoxilizer or a machine says that somebody's blood alcohol or their alcohol concentration, as we say under the law, is above a certain point, is everybody here going to just automatically believe that the machine, number one, is accurate in the first place? And Doctor, I might call on you a little bit on this. Are you familiar with the intoxilizer, any of the science associated with it?
Just a little bit.
And what have you heard about it?
Primarily from Professor Dawson.
I object.
So he told you about when the devil brought the intoxilizer to the GPS. Okay. Anyway, I'm sure everyone here, we're not going to spend a lot of time on this. My DCR has, been blinking 12 for the 5 years I've had it in the living room. I do everything it says to do on my word processor. When I press enter, it says it cannot execute that command. And I know that everybody has had some experience with machinery, be it the telescope that we set up, that the mirrors don't work and all of those, everybody knows that machinery or equipment does not always operate the way it's supposed to, and it does not always do what it is supposed to do. And there's everybody who just has such a strong feeling in favor of science and technology and so forth, that you're just automatically going to believe whatever the intoxilizer says, and not even at least be open-minded as to whether or not it actually does what it purports to do. Is there anybody who feels that strongly? Yes, ma'am.
Well, I feel pretty strongly about it. I mean, unless you're going to show me that it's malfunctioning or something, I feel like it's an objective test, it's very scientific, and I think it's pretty accurate.
Okay. Just for example, one of the bases of the intoxilizer, I think you're going to hear about, is that it assumes that the ratio between the air in your lungs bears some same general proportion as to your blood supply as does everyone else's in the world. And I think, intuitively, you would say people's capacity, their bodily functions, their ability to pass alcohol, all of these things may vary widely from individual to individual. You agree that may be true?
I agree that it's possible.
Okay. And so you agree that it is possible, and just all I'm asking you to do, I'm not asking you right now to say we aren't going to believe the thing that machine has to say. I'm just asking you, can you keep an open mind about that?
Well, sure, but I guess what I'm saying is I'm going to have to hear some evidence that, that it's not as objective and scientific as I think that it is.
Okay. So starting out here, you have some faith in the technology as you understand it, or and you're willing to. I see you shaking your head, sir.
You just said the magic word, faith. I've got much more faith in God than I do in science, so
okay.
I'm a little concerned about anything that,
Okay. And so would it be a fair statement to say that you're willing at least to listen when I am asking some questions of the person who is presenting the intoxilizer evidence as to the basis you just aren't going to automatically believe everything it says?
Oh, no, hell no.
Now, there is another aspect about the intoxilizer that we need to go into now, and you're going to hear about this during the trial. This alcohol concentration, this 0.10, is while you're operating a motor vehicle. And the reason that is important is we all know they don't have the intoxilizers out there in the patrol cars themselves. If I, for example, were to drink not that 5 ounces of whiskey and go immediately out to my car, hop in my car, and drive up to the store, I'm going to submit to you that I would not be intoxicated while I was operating the motor vehicle. And why is that?
Because it would have been in your bloodstream and wouldn't have affected you by that time.
Okay. That's right. It is not absorbed yet into the blood system, therefore it is not affecting my brain, and therefore I would not be intoxicated under the law. For example, if someone were stopped and they had consumed some alcohol, Ms. Ford, and if they had just finished consuming their alcohol, had taken that 5 shots, and the officer stops me out there on Speedway or something, and he smells there's alcohol on my breath, and he decides to place me under arrest, and he takes me downtown, and I take the intoxilizer an hour after that, or half an hour after that, what is going to be the difference between my actual blood alcohol while I'm driving the automobile as opposed to what is measured down there at the police department?
It'll be higher at the police department.
And why is that?
Because more will have been absorbed into the bloodstream.
Okay. So my blood alcohol level would have been perhaps increasing at that point. And in fairness to Mr. Grant, if I had the officer stop me out at the scene and I was in fact very intoxicated, but I hadn't had any alcohol for about an hour, and they take me downtown and there's a long waiting time before I go into the intoxilizer room, what would you expect the difference between my actual blood alcohol while I was driving the motor vehicle as opposed to what is measured down there at the police department?
Your actual would have been higher than what was measured.
Right, because it's going down. What you have to keep in mind is that the state has got to prove, if they're going to rely upon this alcohol concentration, what the alcohol concentration was out there at the scene, or they have to prove that it was above that amount at the scene while I was driving the motor vehicle. Everyone understand that? Okay. And that has got to be proved, of course, beyond a reasonable doubt. What I want to move on to now is talk briefly about what is called the burden of proof. Meaning how much does the state have to prove, or by what quantum or quality of evidence does the state have to prove. And the state has got to prove everything in the charging instrument, the information, beyond a reasonable doubt. And the court is going to give you a written definition of the court's instructions of what is proof beyond a reasonable doubt, and it's going to say something along the lines that a reasonable doubt is a doubt based upon reason and common sense after a careful and impartial consideration of all the evidence. It is a kind of doubt that will cause a reasonable person to hesitate in the most important of his or her own affairs. Proof beyond a reasonable doubt, therefore, must be proof of so convincing a character that you would be willing to rely and act upon it without hesitation in the most important of your own affairs. Now, that's kind of a mouthful, and I'll get back to it in a minute, and the court will also give you that in writing. Let's talk a little bit about the different, what we call burdens of proof, or the different legal standards that are used in the law. About the lowest one is what is called the probable cause standard. Now, that's not something we give a jury an instruction on. You can't convict someone or grant a judgment on that. But that's a standard that a police officer can use to determine whether to place you under arrest for a crime out there at the scene. Probable cause, it sounds like it comes from the word from probable, meaning more likely than not, but that's not what in fact it means. What probable cause means sort of is possible cause. It means enough information that a reasonable and prudent person would believe that a crime may have occurred. If a policeman has enough evidence to think that maybe a crime has occurred, he or she can place you under arrest for that. And that is a very low standard of proof. It may be that that is what we want police officers to be able to do, to intervene if they think someone may be intoxicated out there at the scene, to go ahead and make the decision to arrest that person, to get that possibly intoxicated person off the road at the time. And we leave it, though, the determination that we are here for today to see if the state can prove later beyond a reasonable doubt, where they have the opportunity to bring in more evidence, and more importantly, Mr. Alvarez has the opportunity to bring in more evidence to see if the state can really show or convince you beyond a reasonable doubt that he was intoxicated at the time of operating a motor vehicle. There are a couple of other standards that are used in the law, which I will just give you briefly for illustration. There is a standard of a preponderance of the evidence. If you're suing somebody for money, whichever side has just the very slightest bit more of evidence, either on a qualitative or quantitative scale, that person wins. Just more likely than not prevails if you're suing somebody for money. There's another standard which is called clear and convincing evidence, where the evidence clearly and firmly establishes what the proponent of the evidence is trying to establish, and that's the standard that they have to meet in order to terminate the parental rights of somebody, much higher than the preponderance of the evidence used to sue somebody for money. In a criminal case, though, it is proved beyond a reasonable doubt after a careful and impartial consideration of all the evidence. Again, the court's charge will tell you must be an evidence of so convincing a character that you would be willing to rely and act upon it without hesitation in the most important of your own affairs. Now, that's not, I'm going to submit to you, what we really do out there in our daily affairs. What we really do in our daily affairs is act in spite of the hesitations that we have. Everybody who has contemplated marrying someone or something like that, you may have thought, I really love this person a lot, but we have some problems here. We don't handle disputes the way I think we ought to. There's a little bit more contentiousness in the relationship that I would feel comfortable with. You may have some disagreements about religion or about any number of things that would cause you to hesitate even after a careful and impartial consideration of everything. But what we really do in our real world affairs is we go ahead and we act in spite of that hesitation. We think the core of our love is very strong and true. We have these problems. I think we can work through these and make this a viable relationship. Or I'm going to go ahead and buy that house in spite of the high payments, in spite of these hesitations and doubts that I have that I'll really be able to make that mortgage payment. We'll go ahead and change jobs in spite of all the anxiety I may have about it not working out. And so what we do in our everyday affairs is actually act in spite of the hesitation. But that's not what you do in a criminal case when a citizen is on trial and his liberty can be taken away from him. The court says is, If you have a hesitation after you consider the evidence, you stop at that point and acquit the defendant. Any benefit of the doubt goes to the defendant, and you stop at that point. And if you have that doubt, the benefit of that goes to the person who is accused. Is there anybody who thinks they would have a problem applying that burden of proof and really holding the state to its burden of proof? Okay. There are going to be some police officers who testified. I noticed there was somebody on the jury case who has a relative in law enforcement. Who was that? Yes, sir. Who was that? Who's
My brother, sir?
okay? And what sort of law enforcement officer is he?
He's a highway trooper with the DPS
Okay. How long has he been with the DPS?
for about 7 years, I think.
Okay. Do you talk to him about his work?
Oh, I speak to him, I guess about 5 or 6 times a year, and it's very interesting work that he's in, so we do talk about it, actually.
He's a trooper, a highway patrolman?
Yes, sir.
Okay. Does he tell you some stories about some of the things that happened to him and on the force and so forth?
Yes, it's a lot more interesting than the work I do, so I do enjoy listening to his story.
Okay. I guess the question is, now, your brother, I guess I want to remove this from your brother a little bit, and kind of the general question is, it has to do with the credibility of police officers. And talking to your brother, do you, perhaps not him, but what is your views? Does every police officer that takes the witness stand have a photographic memory and a tape recorder in his brain, and are they always able to relate with 100% accuracy everything that happens out there?
Well, no, sir, I think that even police officers, even my brother tends to sometimes exaggerate at times, make the story a little bit more interesting. I think that just because somebody's a police officer doesn't necessarily mean they're telling the truth.
Okay. And this is kind of a delicate thing, and first of all, I want to say very clearly, I am not expecting at all the police officers that Mr. Grant is going to call to take that witness stand and tell, a lie. I'm not expecting that to happen. It would make my job a lot easier if I could catch some officers, doing that kind of thing. And I think that as a society, we are past the point where we automatically believe everything every police officer ever says. I think the Simpson case in California this last year has shown in a shocking manner that very experienced and officers that appear to be very believable and credible can lie about things. And I want to stress again that I'm not expecting that to happen, but I think that what you have said, if I can put some words in your mouth, sir, are that police officers are in many respects like the rest of us, that we like to make our stories more interesting. We like to, if we're being called on the carpet or made to account for a job that we have done, we tend to make ourselves, look as good as we can, maybe not stepping way out there and lying about it or something, but it is human nature. Is there anybody who doesn't believe that police officers are subject to those very same things? Okay. I prefer to think that police officers generally try to tell it the way they remember it. I think that, Ms. Ford, that you made an interesting point about the officer that stopped you and your husband down there, that he seemed to be, I think you used the word hyper something or other. Hypersensitive. That maybe police officers, because they're in the business of ferreting out crime and arresting intoxicated drivers, sometimes may see more or read more into things because they start with that frame of mind expecting to see those things. Do you think that that's a fair statement?
Yes, I do.
Okay.
Mr. Grizzard, one more minute.
Okay. And so anyway, so what and so I don't want to dwell on that for very much longer, because again, I want to stress that I think that most police officers try to do a good job. And but keep in mind, as you're hearing the evidence, that a police officer only has to have probable cause to arrest someone for driving while intoxicated. Just some basis on which to think that a crime may have occurred. They don't have the benefits that we have here. A policeman who's out there on the scene making a decision in an investigation that just takes a few minutes to perform, he doesn't have the benefit of, for example, knowing what somebody is normally like. When he's seeing the field sobriety test, he doesn't know what that person's normal balance ability is. He doesn't have the opportunity for example, to talk with the people who had been with the person he is considering arresting a short time before. He can't summons them out there to see him and ask them, how did he see him at the party, or how did he see him when you last saw him before he started operating a motor vehicle. That's something that is going to have to, he doesn't have the ability to do that. And so what the law says is that you, police officer, can make that arrest based on probable cause, can take that possibly intoxicated driver off the streets, but before we convict somebody of a crime, you've got to come in and convince 6 people of his guilt beyond a reasonable doubt, and he has the opportunity to call witnesses himself and to provide information and evidence for the benefit of the jury, things that the officer did not have the benefit of out there at the scene. I'll wind it up. Thank you.
Thank both of you very much. Okay, now's your chance to ask both of these questions. Well, before we do that, would each of you talk briefly about what it is that you're really trying to achieve during Voir dire? In other words, what are your goals and objectives? What is it that you're trying to do with the jury? Charlie, you can take
I'm trying to find out as much about them as possible. I think Sam was talking about that when I walked in. Got to get them talking. One good way to do that, incidentally, is to tell them a little bit about how they're selected. Not really selected, but sometimes people say they're actually eliminated, and the quiet ones end up getting picked. And someone doesn't want to be picked, so they're going to start talking. Find out, get them talking, get them at ease, make them feel at ease, and learn as much about them as possible. The little cards are helpful if they tip you off, but you find out you can do it. I've not even looked at those cards. You pick your juries. Forgotten to look at them, I guess. But get them talking, and you're not going to find out anything about them unless you do. And also make them feel at ease. Get like Leon was doing, and I wasn't doing it as much. I don't know the facts of this case, but start selling them on the theory of your case. I was focusing mostly on the mental and physical faculties because I think the breath test was pretty close to 1-0 in this case. So I'm going to be de-emphasizing that like it's no big deal. I've got it anyway. I've got him out there stumbling, which is all I need. And, here's icing on the cake. I've got this .10 or .11. Leon's going to be hammering that and de-emphasizing what he's like at the scene. That's what I guess he would do. Sell them on your own. I've heard good trial lawyers tell me if you don't have them by opening statement, you're never going to get them. And you ought to have them at Voir dire, or at least buying into your way, or open to receptive. Like Sam said in y'all's talk, they ought to know what your case is about at Voir dire. So get them talking and educating, and get them to like you if you can. Not be fake, but just from the easy.
I'd say from the defense perspective, it's not exactly the same. I think if you get people talking too much about themselves, I think the trick is to try to figure out which jurors are going to be good jurors for you without flagging them so the prosecutor will strike them. There are always more good state jurors out there on the panel than there are ones that will be good for the defense, and I often say I don't have enough strikes to get the jerks off the panel, much less start trying to make some sophisticated use of strikes. I think you are better off trying to figure out who the jurors are that are going to be good for you without flagging them for the state. Basically, at Voir dire, you want to, if you can plant some seeds, this is a tricky area, if you can plant some seeds as to what your defense will be or get them comfortable with the concepts that you're going to be using, that is one thing. But too often, if you show your defense too much, you're just going to tell Mr. Grant what to be concerned about and where you're coming from. And so, that you shouldn't in many cases have a problem figuring that out in advance, but the extent to which you can sort of leave the prosecutor in the dark a little bit, it's better if you can do it. And I think basically what Voir dire is all about is making friends on the jury panel, getting them to think that you're professional about what you do and that you're a reasonably nice person and that you're reasonable about things and you don't seem like you're just a blind advocate, for one side or another. I think that people appreciate people that are reasonable. So that's what I do.
Charlie, which jurors would you try to strike?
Definitely Mr. Bird, And the problem is Ford, if I had an extra strike. I just personally, and, Burleson wasn't that great either, even though he's been around and drunk a bunch of strikes. He probably would minimize this case. Oh, that guy wasn't drunk.
Yeah.
Because he wasn't falling down. So, everybody.
Well, I like Ms. Ford. I thought that she seemed reasonable. Mr. Burleson, although he's good for me, he's a nutball. And I may...
That's not an act, by the way.
And so there are often times when people will want it, from the defense side, you sort of might want some loose cannons on there, but he worries me a little bit. Certainly Mr. Daly down there on the end, he's certainly history. And I would be making a run at him for a challenge for cause up at the bench on the basis that he just could not be fair and impartial and has some bias against my client.
What about the doc?
Oh, I hate doctors. They're gone. They're automatic for me.
I would have used him a lot more, talk about the effects of alcohol. Also, and I've never had a chance to do it, but y'all, defense lawyers always make a big deal that the officer has to rely on his notes. And I was thinking, well, who else relies on notes? And if a doctor didn't take notes about my visit, and then 6 months later, if I didn't see him looking at my past notes, I would get out of there and leave. So I'd ask the doctor if he takes notes, why, to help me remember so I make a valid judgment when I look at it 6 months later, to let the jurors know that, hey, it's reasonable for my officer to have written an offense report. And also, do you sometimes remember things, you put things in there, sometimes you just remember, you don't have to put everything in there, do you? Stuff like that.
The trigger, yeah, right, that.
So I would have done him, and I don't know about, if I would have found out what he thought of the toxicologer.
Well, one thing I think you have to keep in mind is that you kind of have to read behind what people are saying a lot. People aren't going to cozy up to me very much. It's easier on a driving while intoxicated. It's a lot easier to be fair on a misdemeanor case and on a murder or something. But people are going to be, I try not to get people to cozy up to me very much. Number one, if they do, then Charlie will strike them. And number two, people just don't feel comfortable about doing that. And so also people will say things out here that you can tell, somebody may say that they, couldn't ever believe the intoxicologer, have some, bias against that, but when they really get back there, they may actually do fine with it. I think that you kind of have to look at the kind of people they are, and if somebody, you think they're a reasonable, thoughtful person, even if they seem to be having a problem with one aspect of the case, that may not absolutely be the way they really are going to view the evidence when it comes down to it, and they've taken the oath and, and have actually heard the evidence.
I would also add, I think DWI voir dire is particularly important, because in a DWI case, you're dealing with opinions and a lot of subjectivity as to what is normal, and particularly in a non-breath test case. And so getting a juror's background and attitudes about drinking and driving, it's just so important. The DWI cases I've been successful in, I can usually tell after voir dire whether or not.
I remember that.
Got one, yeah.
Questions? Have your chance to ask real lawyers.
Yeah. Just the mechanics of when you select out a juror that you want to dismiss for cause, how do you go about picking them out and pulling them up in front of the judge in a way that seems least hostile?
The way that normally is done here, and they do it in other places as well, after both sides have finished the voir dire, there'll be 2 or 3 people, maybe someone we did somebody who wanted to approach the bench, we had him stand up here. So we have everybody who wants to approach the bench, or that we need to have approached the bench for one reason or another. The judge, after voir dire is completed, the judge says, step up, attorneys, who do you want up at the bench? Then we have them approach one at a time.
Since you're the first one to speak, how often are you inclined to go ahead and poison the well with something on the case?
Oh, if I get, like Sam was talking about, you get one guy, or if Leon had somebody on there, you get somebody that's in your camp told that they could be number 50 in a felony or 18 or whatever, and like a police officer, and depending on the facts, you get that person talking, what's it like being out there? And like in a resisting case, what's it like? You don't know what's going to happen when that car door opens. You get them to poison it in your favor as much as you can without making it look obvious what you're doing, but always go back and hit them. Like I would have talked about with Dr. Red, how alcohol affects people, and he was doing great. He did great in 30 seconds and did more than I could tell in 5 minutes. And Leon would do the
I
same.
absolutely agree. Or what I will do is, if I see somebody, it's a certain type of case, and I can see somebody is doing that, and I can tell that somebody that I may have a opportunity to challenge for cause, I want to go after that person first. And I want to try to take them out, because after and try to get them to make that answer that will cause them to be excludable, because after the panel has heard a few people do those lines of inquiry, people start figuring out what they're supposed to say. And so I usually try to, if there's some people that I think I may have a run at, I try to start that line of questioning with them as my example people, so they don't have a chance to figure out how to answer the questions.
I'm just curious about the group dynamic that goes on within the jury. When I've been a veneerman and watched what happened, it appeared to me like everybody was sort of auditioning to be in the jury. Instead of, everybody was, I guess I could be very impartial about that issue. Is my experience just unusual in that respect, or does that have some...
I think the dynamic is there. You see it all ways. I mean, sometimes you see people that obviously want to be on the jury. You see people feel hard to get off the jury as well. You just kind of have to lead it. And I think that's what it is, that people are making a public statement about themselves, and that may or may not be what they really are like underneath, or when push really comes to shove on the thing. And so you have to look beyond that, or read between the lines and try to separate out what is the public posture versus what they really would be like if they had the responsibility.
Doctor, are you a fair person?
Sure.
Are you ever going to admit to in front of 18 or 50 So you ask things, get into experiences like they were talking, to find out and conclude yourself whether or not.
Right.
And also you have to, like, when you take them up, like I'm gonna bring up Mr. Bird and how I'm going to keep from offending him when I go up there. Did you ask something? A lot of times if you call somebody up and you don't get him or her struck for cause, you're going to have to use a strike on a lot, because they're going to understand what's going on, but you just be ginger and say, well, you said this and I have a question, does that mean this, or you wouldn't, things like that, and lead them where you want them to go. Be ginger though.
So do I understand that if you're striking somebody for cause, you wait till after both sides have gone?
Right. Every place I practice all around here in the area, you do those, at the end. That's right.
And that's when you do peremptory strikes also, right?
Well, you do your challenges for cause first, and then you go and strike your list, knowing who's been struck for cause. Yes, sir.
I'm assuming there's no interplay between counsel when you're addressing the jury pool. You objected at one point on a silly matter, but when he's addressing, you can't interrupt him.
I mean, it certainly can.
Oh, you can.
I can object.
Well, he certainly can. We certainly can object to misstating the law or something like that. From the defense perspective, voir dire is the only chance you ever get to close the proceeding. The state, gets to open and gets to do their argument first and last. They put their evidence on first, and they can put on the rebuttal, at the end, and so forth. So voir dire is the only chance that the defense has the last word, and so that's a valuable thing for us. It's an opportunity to make a little speech right at the end as we're trying to, we're winding it down. Also, just in general, what experienced attorneys do, if you've got some stuff that may be objectionable, you try to mix the objectionable in with the unobjectionable. Do 3 or 4 unobjectionables and slip in a little, a marginally objectionable thing, and then back away from that, and you may get your, before you start doing it, you've done quiet, and so that's true on cross-examination as well. Try to cheat carefully.
Your teacher, Mr. Howe, was very good. I tried a case, actually, it was against CDC, and he was good at, when I was doing my voir dire, kind of finishing my sentences for me, and it was annoying as all get out, and I obviously didn't annoy the jury. But, and he'll do that, and then, like I could have said something when Leon's talking about the probable cause, and I could have said, well, a judge needs to sign any affidavit to hold the person, which is what I probably would have done, so it's not just a cop's word, it's a judge's sign off on that too. But yeah, you can, it's a game, that's all it is. And just be the good guy.
Yeah, I think I was trying to be the soul of the reason, no matter which side you're on. I mean, there are a lot of attorneys that have been very effective here in town that are jerks, and the juries try to do the right thing in spite of the lawyers, but I think you're better off seeming, reasonable and professional.
Any more questions?
I'm sorry to monopolize this. I had a question about, I took your time while you were getting ready to tell us how you would talk to the jury about the preponderance of evidence, and so you didn't get time to do that. And I'm just curious what I've got to look forward to as the other point of view.
How I foregone on it?
Yes.
I'd go by reading the same the same statement. Wow, Leon had it memorized. I read it off that portion of it and tell him that's going to be in the charge. And I say things like give him my secrets here. There are inconsistent things in there. First of all, it says careful and impartial consideration, and then it says you can't hesitate. And I ask people, do you think that means they have to go into that jury room if they're picked, and if they don't march immediately right back out with a guilty, that the person's not guilty? And they go, no, we have to look at everything. And then with the marriage thing, I talk about who's married, and is that a pretty important thing in your life? Did you have some doubts? Were you a little worried maybe? Or walking down the aisle, were you scared? Sure. Did you wonder how you're going to make it financially? Sure. You went ahead and got married, didn't you? Yeah. Well, in that situation, you didn't have a reasonable doubt about that marriage, because they focus on hesitate, we focus on hesitate to act. You went ahead and acted, so the key word there is act, not hesitate. Because you have to carefully and impartially consider everything, and then if you don't act or hesitate and do not act, then...
I think the reasonable doubt instruction has caused prosecutors a lot of trouble, and obviously they're still trying to find an effective way to deal with it. It used to be, up until 4 years ago, we didn't have a reasonable doubt instruction. It just was whatever you wanted it to be, just if you had a reasonable doubt, and there was not a definition. Now that we have the reasonable doubt definition, it really has prosecutors having some, that language I was emphasizing, is in there, and I think the best way for prosecutors to do it is just to blow right past it, say, that's right, that's the law, and, and find argument, say, we're there, you shouldn't have any hesitation, because trying to pussyfoot around at those words, I think, it just doesn't quite, I haven't seen Charlie's Voir dire, so I can't say this about him, but I haven't seen anyone that I thought really has dealt real well with that language, and so I think that what they need to do is just say, whatever it is, this is it, and by golly, we're there. And
ton of examples and not done. I always read it and get them ready for it, and talk about the consider, and that it doesn't mean you have to turn around and walk back out and hesitate, and I've left it alone and done it, and it's worked both ways. It's tough. Jurors go, if they think he did it, they're going to vote guilty, basically. And if they don't, then that's where y'all can say.
Thank you very much.